Welcome to the IAPP web conference, Protecting Student Medical Privacy, Analyzing the Landscape. My name is Dave Cohen. I'm the IAPP's Knowledge Manager, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's program will automatically provide IAPP certified privacy professionals who are the named registrants with 1.5 CPE credits. Others who are listening in can apply for those credits through an easy-to-use online form on our website. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. We encourage you to ask questions at any time during the program via the text function to the right of your PowerPoint window, and your questions will be answered by the panelists toward the end of the presentation. Now on to our program, and for that I would like to turn the microphone over to Brenda Leong, who's going to be the moderator for today's program. Brenda?
Thank you, Dave. We're going to skip forward just a little bit. We're very grateful that we have the opportunity to have Congresswoman Bonamici and Senator Wyden with us today to give us a little background on the question that brought us all together and that we're going to be discussing in more detail shortly. And in order to maximize their time, we're going to let them start off. Congresswoman Bonamici served in the Oregon House of Representatives and the Oregon Senate. In September of 2012, she was sworn in as a member of the U.S. House of Representatives. She serves on the Committee on Education and the Workforce and the Committee on Science, Space, and Technology, where she is a ranking member on the Subcommittee on Environment. Congresswoman Bonamici?
Well, thank you so much, and I want to start by thanking Senator Wyden. I'm really pleased to be working with the Senator and with the IAPP to protect the medical privacy of students. And I want to thank the International Association of Privacy Professionals for hosting this discussion today. I wish I could stay with you the entire time. I'm about to get on a plane. I also want to thank the conversation moderator and all the panelists. And I say there is a real need for this discussion that we're having today. The treatment of sensitive medical records on campuses is quite complicated. There's many institutions that comply with both the health insurance portability and accountability HIPAA privacy rules and also FERPA, the Family Educational Rights and Privacy Act. And Senator Wyden and I sent a letter to the U.S. Department of Education, and even the U.S. Department of Education is wrestling with how these separate statutes and their corresponding regulations affect the way institutions handle similar patient information. The complicated landscape is difficult not only for students, but also for administrators, providers, and other professionals. But my primary concern is that any confusion about how the student's information is handled may discourage students from seeking treatment, and that would be a serious issue. So we need to work together to ensure that the students, that when they go to get counseling and medical treatment, that the information will be adequately protected. And that means we need to do a much better job of communicating with students and families to help them understand not only their expectation to privacy and also educate them about the exceptions that can allow information to be shared without consent, but also assuring that the medical information will be treated appropriately is also going to need policymakers to consider whether the existing privacy laws and rules are sufficient to uphold that privacy that students need to have and expect. So it's great that we're having this discussion today. It's, I hope not the first time we'll be discussing this critical issue together, and I'm looking forward to continuing to work with Senator Wyden and others to examine how we restore that confidence in privacy protections for the medical information of students. And again, thank you to all of you who are participating. Thank you again to IAPP for hosting the conversation, and certainly to all the participants and listeners for their interest. And I will be following up to find out how the discussion goes after I'm back on the ground. So thank you again, Senator. Thank you, IAPP, and hope for a good, productive discussion. Thank you.
Thank you very much, Congresswoman. Senator Wyden is the ranking member of the Senate Finance Committee and a senior member of the Senate Select Committee on Intelligence, where he serves as a staunch supporter of Americans' privacy rights and civil liberties. Senator Wyden has represented Oregonians in Congress since 1980. Senator Wyden?
Thank you very much, and it's very, very helpful that you all are holding this forum to address some, I think, urgent issues with respect to student medical privacy. And I consider it very helpful that you've assembled an all-star panel of experts in privacy and healthcare policy. And I especially want to take note of Congresswoman Bonamici, who has shown significant leadership on this issue. My sense is that the challenge in front of us is straightforward. No matter where our students go for help, they absolutely have to have confidence in their treatment. Students must have the certainty that the information they share with their healthcare providers, which is often just about the most intimate, personal, private information imaginable, those students have to know that that information is going to be protected. Because without the ability to have a candid conversation about the kind of matters that I just described, which I consider about as sensitive as you can imagine, patients may well not get the diagnosis or treatment they need, or may not seek treatment in the first place. Over the past few months, certainly matters have gotten even more challenging as the onslaught of media discussion has surrounded the privacy protection of students' treatment records. So I think what this has generated is a sense that students are entering higher education at a particularly sensitive time in their lives. As adults, living on their own in many instances for the first time, tackling new academic and social challenges, very often they're without the familiar support of family and longtime friends. They're also taking over the responsibility for making decisions about their physical and mental health. Now, luckily, in much of the country, there are a variety of options for students who seek care: campus counseling centers and health clinics, university-wide health systems offering a variety of options, and in a number of instances, private medical practice. Unfortunately, a great deal of confusion exists as to how those students, who often are navigating the options for the first time, can figure out how to proceed with the choices that they want. Those news reports that I mentioned seem to have raised more questions than they've answered with respect to how the two laws, and like everything in Washington, you have to have an acronym, HIPAA, which is about privacy, and FERPA, which is also about privacy in the family educational rights arena. And there are questions about how these two laws apply to college students. And they really aren't just acronyms and kind of Washington lingo. They really address bedrock privacy issues that are so important to students and families. In trying to help answer those privacy questions, and this is something that I've focused on since I came to the Senate in 1996, Congresswoman Bonamici and I wrote to the Department of Education asking the department to clarify how the Family Education Rights and Privacy Act applies to student medical records, including therapy and treatment records held by educational institutions, and how the level of privacy protection differs for on-campus versus off-campus health services. Last week, the department responded to us saying it was concerned, and I quote here, about the possibility that FERPA may offer fewer confidentiality protections than the HIPAA privacy rule does in some instances. So what we're going to be doing is following up to see what are the next steps that ought to be taken to better clarify what this would mean for America's college students. One last point that I like to make, and this goes to a question that really hasn't been debated enough, and I would just, in wrapping up, say that we would like your thoughts and counsel on it. Part of what has complicated this issue is the college, the typical college across the country, now wears multiple hats. You have the university employee often filling the role of professor, academic counselor, coach, medical doctor, and therapist. And as a result, a school has to administer records when students are served under each of these capacities. So there is something of an inherent conflict of interest in the very underpinnings of the modern university, a conflict of interest that is almost embodied in the structure of the modern university. And how we think about reconciling those conflicts that I've described, how we go about coming up with policies to address this issue is going to be very important in shaping federal policies so that students can be truly confident in the care they receive. And let me just wrap up by way of saying that I think your group, the International Association of Privacy Professionals, is doing exceptionally important work. I decided that I was going to go back and think through kind of privacy, issues, and I'm reading Patrick Moynihan's book called Secrecy. And Senator Moynihan says secrecy is for losers. And I think what we've got to do is figure out some ways to protect people's privacy. He was, in effect, my predecessor on the Senate Finance Committee, and I think that sums it up. So big thanks to all of you for figuring out how to tackle these issues, protect the privacy of our students, and to think creatively about the big challenges in the days ahead, such as dealing with that inherent conflict of interest. Look forward to hearing the results of your program. Bye now.
Thank you very much, Senator Wyden. We're going to back up a couple slides now and start with the introductions for our panel today. We're going to take on that challenge that the Congresswoman and the Senator just laid out for us to think about and evaluate these questions and figure out a way ahead. I am Brenda Leong. I'm the Senior Counsel and Director of Operations at the Future of Privacy Forum, which is a Washington, D.C.-based think tank that is focused on consumer privacy issues generally. One of the areas in which we focus is education and student data privacy. Several of the things that we've done in that field are directly involved with FERPA, the education of the rights available to parents and students under FERPA. Recently, only about a month ago, in partnership with Connect Safely and the National PTA, we put out a parent guide to student data privacy rights under FERPA. And so that is, in particular, our background and expertise. And then working with those who also understand HIPAA to that same level and pulling those laws together and how they apply in the questions we're addressing today. Our other panelists are Steve McDonald, Kirk, Nahra, and Sarah Van Orman, and I'm going to let each of them take a minute to introduce themselves and give you a little bit of their background so you know who's discussing the topics today. Steve, if you could kick it off.
Sure. I'm Steve McDonald. I'm currently the General Counsel at Rhode Island School of Design. I used to work at The Ohio State University as a counsel there, been in higher ed for 23 years, a lawyer for about 30, and for much of that time I've been dealing with FERPA.
Kirk, if you could let us know your background.
Thank you. Yes, Kirk Nahra. I'm a partner with Wiley, Rein in Washington, D.C. I've been working more on the healthcare side and HIPAA issues since basically the beginning of HIPAA back in the late 90s. Also been involved with IAPP for many years after serving on their board for many years, and been involved with their leading publication, The Privacy Advisor.
Thank you, Kirk. Sarah.
Yeah, good afternoon. I'm currently the Executive Director of University Health Services at the University of Wisconsin-Madison, and I'm also the immediate past president of the American College Health Association.
I'm a primary care physician by training, and I've spent my career in college health, so working with this both as a physician and practitioner, as well as the director of a university health service that includes both medical and mental health care, and then also most recently thinking about this in our sort of national policy role as college health professionals and college health centers across the country.
Thank you, Sarah. So our program for today will look something like this. We've already had the framing of the question by the Senator and the Congresswoman in our introductory remarks. So we're going to move on into the presentations by each of the panelists on the student medical privacy landscape. We'll spend a few minutes on that, and then what we really want to focus on is some specific scenarios, and we have 3 that we've outlined in advance that we will lay out for you and invite our panelists to discuss and comment on. After that, we will open it up for questions. We have, of course, a few prepared questions to try to address what we feel like are some of the key points on this issue, and then we will be taking questions from you as well, and hope to be able to answer those, if not all directly here, at least in context with the other questions that or other answers that we can provide, and then we'll wrap it up. So to begin, as Senator Wyden laid out fairly clearly, there are a number of laws that address student privacy or individuals' privacy in a number of contexts. FERPA is designed to focus on educational issues and HIPAA on medical privacy issues. And the question becomes, when or how do they both apply, or neither apply, or overlap, or what other conflicts might there be between those two? So we're going to hear from each of our panelists on this topic, and I'm going to start with Kirk.
Thank you very much. Usually when you do talk about healthcare privacy or medical privacy, what you're focusing on is the HIPAA privacy and security rules, which have been in place since the early 2000s and apply to a wide range of doctors and hospitals and health insurers and government healthcare programs and lots of other entities. And for most people in the country, the HIPAA rules are really what govern protections of medical privacy. However, it's also very important to understand, both generally and then in the context of what we're going to be talking about today, that HIPAA has always been a limited scope privacy and security rule. It is not a set of rules that protects medical privacy in general. It applies to healthcare information only where something called a covered entity is involved. We'll get to what that is in a second. But that means that you have to have the right kind of information being held by the right kind of entity in the right kind of situation for the HIPAA rules to come into play. And so one of the issues we've been dealing with in the broader healthcare industry is the many gaps that exist when entities collect and maintain healthcare data but are not covered by the HIPAA rules. And many people who are listening and college students and others in the field are dealing with things like mobile apps and certain kinds of websites and lots of kinds of places and entities that gather healthcare information but that aren't covered by the HIPAA rules. So that's a major issue that we're dealing with in the healthcare industry. It's one component of what we're going to be talking about today. Now, in the setting we're talking about today, again, HIPAA applies to a term called protected health information. And what that essentially is individually identifiable information, meaning it's about an individual, and you can tell that it's about an individual when it's created by or held by a covered entity. And what that means are essentially there's 3 categories. They're called healthcare providers, including doctors and hospitals, health insurers, or health plans is the term in the rules, which is, again, your traditional health insurer. It might be an employer that provides healthcare benefits. It could be a government healthcare program. Or something called clearinghouses, which really aren't that important in this context. They're very limited business applications. So one question for healthcare providers is that the rules actually don't even apply to all healthcare providers. They only apply to healthcare providers that use certain kinds of standardized electronic transactions to sort of short-circuit that a little bit, what that means is a doctor in a hospital who tends to submit bills for treatment electronically. There are some other complications, but one issue that always applies on campuses, and particularly applied on campuses early on, was whether a campus clinic was even a healthcare provider if they didn't bill somebody for the healthcare treatment. So that's an issue to think about. But then you move on to the specific issue that we're dealing with here. We have a HIPAA rule that covers protected health information, but then the rules say that the definition of protected health information excludes individually identifiable health information if that information is in education records covered by the FERPA Act. It also then excludes, and this is just a statutory site, but it excludes essentially other treatment records that are governed by FERPA. So what we end up when you put those together is that for the most part with particular records, and we'll hear about this from the other speakers in a couple minutes, HIPAA and FERPA tend to be mutually exclusive. If it's covered by HIPAA, if it's covered by FERPA, it's excluded by HIPAA. That means that HIPAA only applies to things that aren't covered by FERPA. So for universities and other settings, that creates a lot of real compliance challenges. We're going to talk a little bit about these in the scenarios today, but that comes up in a couple of contexts. One is where a university, as is certainly common in lots of facilities now, operates another kind of medical facility, a hospital, particularly if it's an academic medical center, because they have to apply multiple sets of rules. They're not only treating students where the records might be FERPA records, but they're treating staff, and they're treating spouses, and they're usually treating people in the community. They're doing research, etc. So it creates some real compliance challenges for the universities. And then you need situations where the university needs to get protected health information from non-university healthcare sources. So again, creating lots of confusion, just as Senator Wyden referenced. There's incredible confusion in this area. Then, to make it even more complicated, you also throw on top of this the fact that there are hundreds, probably thousands of laws across the states at the state level that deal with healthcare privacy in various settings. And those laws apply in completely different situations. They don't reference HIPAA. They don't reference FERPA. They don't have exceptions. They don't try to apply that. So we have lots of confusion there. A lot of these states have particular laws dealing with what is often called sensitive conditions, mental health, substance abuse, things like that. All states have laws about doctor-patient confidentiality. Most states have many other kinds of laws like that. We're even seeing some states that have what we're calling mini HIPAA laws, which are broad general privacy laws that sort of mirror the HIPAA rules, but that doesn't mean that they have every provision of the HIPAA rules. For example, they may have the scope of a HIPAA rule without some of the exceptions, like the exception that carves out FERPA records. So it's an incredibly complicated landscape, and it's one that creates real challenges to manage and to apply these laws for the entities that have to follow them. But I also think it creates enormous confusion for individuals, because individuals have to figure out, if they can even try or even know there's differences in the laws, where they go, what rights they have, what protections they have, and that's particularly complicated where there's these overlaps in how the rules apply. So with that, let me pass it back to Brenda, and we'll move on to the next speaker.
Okay, Sarah, you're up.
Great. Thanks so much, Kirk and Brenda. So I'll just say a bit before we delve a bit deeper into FERPA about the nature of healthcare that's provided on campuses. There's a great diversity of sort of both the structure and the administration that can add complications to what set of laws the federal laws our campus health centers are under. A bit about campus healthcare. We think there's probably about 2,000 on-campus health centers at the various institutions of higher education across the country, and they're all very different. We have centers, as I've laid out here, that are really integrated, where there's medical and mental health care together. We have centers when those are separate. We have centers where we may have medical services in one place and counseling somewhere else. And then we have many campuses that have no on-campus services. Many of our campus health centers are really owned and operated by the institution that they're a part of. So the physicians and psychologists and nurses really work for the institution. But there's lots of other examples where they may operate, but then they contract with another healthcare organization to provide those healthcare providers. Sometimes we have an outside entity coming in and operating our health center. For example, when we have campuses that have an academic medical center, and then sometimes students are referred off campus. In each of those cases, the who sort of owns those treatment records and whether they're a HIPAA-covered record or a FERPA-covered record is going to look a little bit different. So that's some of the complexity that we're looking at even within a sort of campus health center. Then just kind of talking a minute from what it looks like on the ground as a physician at a healthcare center and as a director, you know, we really view ourselves first as medical and mental health providers that are bound by the legal and ethical requirements of our profession. We really view our first duty as to our patient and our client. And as we move to some of these scenarios today, we can see where that might come into conflict with maybe what the larger institutional needs are. We are sort of uniquely situated, though, as healthcare providers that work for an educational rather than a healthcare organization. And those of us who've been in college health for a long time have really always walked this very interesting balance between understanding that we have records that are covered by FERPA, we may have records that are partially covered by HIPAA, and we also then have to meet the requirements of whatever our state medical confidentiality laws are. Those of us who provide care, for example, to a spouse or to an employee actually are covered by HIPAA for those visits. There are also some unique provisions of FERPA that actually prohibit disclosures that are actually permitted under HIPAA. So it is a very complex environment that we work in, understanding that we have several different sets of rules that are operating at once. The other thing I'll mention, and I think Senator Wyden alluded to this in his opening comments, is that many providers have multiple roles within the institution. They may provide health care, but then they may also participate in other educational and teaching activities, and sometimes those roles are in conflict, and the providers need to sort out what hat they're wearing when they obtain sensitive information to know how that information can be disclosed or not disclosed. And then I think finally the other complexity of this is the representation by institutional counsel that might have one duty to represent their healthcare providers, but also then have a duty to represent the institution of higher education. Those may be at sometimes in conflict, and then they're also, depending again on the size of their institution, institutional counsel may not have specific healthcare or mental health care information privacy expertise. And all of those things are certainly complicate some of the questions that we have as student health providers and centers when we're dealing with particularly complex release issues. So I know we'll talk more about this in the scenarios, but at this point I'll turn it over to Steve, who'll talk a little bit more, I think, about FERPA.
Great, thanks. And yes, I will. So HIPAA is a very specific statute dealing with medical records. FERPA, by contrast, is a very general statute that sets a floor for virtually all of our student records. It doesn't set the ceiling. There are other laws that may apply to specific kinds of records and provide additional requirements and protections, but this is the floor that applies to essentially all student records we have on our campus. At the college level, it's a little different at K through 12, but at the college level, our students have three main rights, and there are a lot of nuances to this, but in general, they have the right to have some say over when and how and to whom we can disclose their education records. They have the right to access, to inspect and review their own education records. And in certain circumstances, they have the right to ask us to change, to modify, to correct their education records. So the big question is, what is this thing that we call an education record? And that is FERPA's version of protected health information, the organizing definition that FERPA uses. So the statute is quite broad. It defines education records as any records that are just two things. They're directly related to a student, which essentially means personally identifiable to a student, and they are maintained by the educational institution or by someone acting on behalf of the educational institution. Very broad definition. It does not cover only academic or educational records, but rather almost all records on our campuses. There are 6 narrow exclusions, however, from this definition, one of which is quite important for us here today, and that is the exclusion that covers what are typically referred to as treatment records. And here is the definition of that. So the definition of education records says the term does not include records on a student who's 18 or older or attending an institution of post-secondary institution, so college student no matter what the age, if those records are made or maintained by a medical professional or paraprofessional acting in his or her professional or paraprofessional capacity. They are made, maintained, and used only in connection with the treatment of the student, so for purpose of diagnosing and treating some kind of medical condition. That can be a physical health condition, it could be a mental health condition. And finally, that are disclosed only to the individuals who are involved in providing that treatment. Now, I want to go into this definition in a little more detail, but I also want to point out that this does not cover all medical records on our campus. Just as HIPAA does not cover all medical records, treatment records is not all medical records. There are many medical records on our campus that are not considered treatment records and therefore would be considered education records. For example, your disability accommodation or disability services office has records about medical conditions that they use for disability accommodations. Those are not used in connection with treatment and therefore are considered education records. If you had a medical release for a field trip that had medical information on it, that would not be covered. So the real question is, why is this definition even here at all? Because it looks like it's carving these things out from FERPA altogether and providing no protection for them at all. But that's not true, and we need to focus on this last part of the phrase. The definition built in has a sort of restriction, although it's an optional one. It qualifies for this exclusion only as long as it's not shared with people who are not involved in providing treatment. If it is shared with someone else, it becomes an education record and all of FERPA clicks in. So this leads to sort of some weird metaphysics here. Many people have interpreted this to mean that FERPA allows the disclosure of treatment records basically to anyone that we could disclose other forms of education records to under FERPA. I think it's more accurate to say that FERPA does not prohibit the release of treatment records to people other than those involved in treatment. As far as FERPA is concerned, you could share treatment records with people under any of the exceptions, including the school official exception, which allows us to share records internally for job-related purposes. That said, FERPA does not require that form of disclosure. It simply does not prohibit it, and the reason this provision is this. The real reason for carving them out from the definition of education records was not to make them generally available. There's still the rest of FERPA that applies, but simply to take them out of the inspect and review right. Students have a general right to inspect and review their education records under FERPA, but not treatment records. FERPA has chosen to defer that question to state law on when patients have access to their own records, as long as they're not shared more broadly. And the reason for that is that every state has a law that governs when patients can have access to their records, and typically those state statutes provide that if it would impair the health or the treatment of the patient, the provider can withhold the record, at least under that narrow circumstance, whereas the FERPA right is essentially absolute. Now, as Kirk pointed out, these records are not protected by HIPAA because the definition excludes both treatment records and education records from the definition. So it looks as though these records are essentially unprotected at all. But that's not the case, and the key is this. As I said, FERPA is a floor, not a ceiling. Every state also has a series of state medical confidentiality rules. Kirk introduced us to those that are applicable in particular to healthcare providers. And FERPA in no way trumps those. So it doesn't allow a medical provider to do something that would violate his or her state medical confidentiality rules. It doesn't prohibit that, but it also doesn't authorize that. And every state law typically has significant restrictions on when healthcare providers may disclose patient information. Typically, they may do so only, first of all, if they have the informed consent of the patient, which is the catch-all under pretty much any medical statute. Also, in connection with professional consultations, when providers are consulting with each other about a particular case in order to provide better treatment, that is typically permitted. Also, in rare circumstances, if it's necessary to protect the patient, the provider, him or herself, or others from significant harm, this is sometimes referred to as the TerraSoft standard under a California case that established that in some cases, medical providers may not only have the right to disclose, but may actually have a duty to disclose, a duty to warn if a patient presents a significant threat of substantial harm to others. Typically, providers may also disclose information, at least to the extent necessary to collect payment for services rendered. If they're not paid, they can disclose that someone was their patient and that there's an account owed. Probably not the entire patient record, but at least that amount of information. And then finally, there is typically an exception for when the privilege, the patient-physician privilege has been deemed waived. That can happen under a number of circumstances. And one of the most important ones is when a patient files litigation that places his or her medical condition at issue in some way. It might be a medical malpractice suit against the physician, or it might be something that involves a different kind of claim against someone else, but involves, as a measure of damages, whatever harm there was to the person from a mental health or a physical health perspective. So that is a very quick overview of the FERPA interplay with these other statutes, and I'm now going to turn it back to Brenda to take us into our scenarios.
Thank you, Steve. Thank you to all the panelists for all that excellent information. I understand for everyone watching and listening that was a lot of information laid out, and a lot of it sort of very highly technical or legal, trying to refine definitions and how they work together and what's excluded or included or things like that. So what we hope to be able to do next is actually lay out some specific scenarios of a student in a particular situation and how all of those things that we just discussed would apply. Who could see the records, who would have the authority to share them or release them, who wouldn't, who would explicitly be prevented from that, and those kinds of issues. These are just several possible situations. We obviously can't cover every possible scenario here, but hopefully they hit some of the primary situations that we're likely to encounter or that have been discussed prior to this. So to start out, a university under Title IX investigation and the student has received medical care at an on-campus health center. Who and under what conditions can these records be accessed? So Sarah, I'd like to start with you if I could and have you address that question.
Yeah, so this is kind of a scenario to get us started. The question here is, for example, clearly that there's a sense that the university has not handled this student's, there's a concern about the investigation related to, I'm assuming, kind of a sexual violence or sexual assault. The student may have had medical care at the health center. The question is, can the university, in their role as responding to the Title IX complaint, access the student's record at the on-campus health center? So I'm going to obviously get my colleagues to weigh in here, Kirk and Steve, but as a health center director, we would not allow the university to access the students' medical records about the care they had received as part of the university's response to the Title IX complaint, that care they had received was confidential, and without a specific consent from the student, that would not be permissible. Now, there's a follow-up question I'll throw out to the others related to would those records be accessible by the federal investigators and OCR, and I'll ask others to comment on that. But we would not allow access to those records.
Steve, can you weigh in on that as well, please?
Sure, and I will definitely address that last question as I go along. So I would break this down into actually a series of questions, and the first one would be, who is it who's asking to see the records? It might actually be the student, him or herself, who is looking for the records to support the charge. And a student is almost certainly going to have the right to access his or her own records. It might, as Sarah suggested, be OCR, and under some circumstances, when they are conducting an investigation, they may have the right of access. And the third possibility, or at least the third of maybe several possibilities, would be the school itself, beyond the health center, looking for records in order to defend the charge that has been brought against it. And that might be campus counsel, it might be other parts of the institution. Next question for me is, would the records in the health center even be relevant to the claim? And that's going to depend on the nature of the claim. If the Title IX investigation has to do with the provision of health care itself, then absolutely it's going to be relevant. But if it's not about the health care itself, it may or may not be relevant. It might be that the student is complaining about sexual harassment in a class, and the medical care, the counseling is totally irrelevant to that, and then nobody should be looking at those sorts of things. And then a final question to just figure out which set of rules we're under is going to be, is the health center we're talking about here, this on-campus health center, is that the student center, in which case we are dealing with FERPA and the overlay of state law, or is it the broader public hospital, for example, which might happen to be treating someone who is a student, but as a walk-in patient that on the same basis as the public could be treated, in which case we would be dealing with HIPAA as well as those various state statutes. Now, just to go back to FERPA, and I'll then turn to Kirk for HIPAA, as I said, FERPA would not prohibit sharing that information with people on campus if, for example, it was needed to defend the claim. However, FERPA does not permit the sharing if state law would not permit the sharing, and so we would have to fall back to the state statute. Every state statutes are different, so what I'm saying here is not certainly going to apply across the board. But if the claim specifically has to deal with the health care provided, I believe that under almost any state statute, the counseling center itself would be free to consult with campus counsel to determine the nature of its defense and to help to defend the claim. That would be a waiver. If it didn't relate specifically to the medical care, we'd be in a different situation under many state laws, and I believe, and I'll turn to Kirk now, I think we also would do that different under FERPA, or under HIPAA. But I want to point out that when the physician or the counselor contacts on-campus counsel for that purpose, they are operating under two sets of privileges that dock together. So even though that consultation takes place, doesn't necessarily mean that sharing can then continue beyond that. So keep that in mind. But Kirk, what about HIPAA?
Thanks. Yeah, I mean, the HIPAA process is obviously a very different process. And let me just use the example. Let's just say that the student, let's assume for a second that the student's health is relevant to the case. And I realize, as Steve said, that a lot of times it wouldn't be. But let's just say it's relevant to the case, but the student sought treatment at an off-campus, a regular doctor, a regular hospital that's not associated with the with the university, we'd have a totally different set of rules that apply to that, and there's a set of rules that deal with subpoenas and litigation and things like that. And it essentially, as long as certain process steps are taken, it actually allows a lot of information to be shared in connection with litigation. So I think that one of the sort of overwhelming points that ties into what Senator Wyden said at the beginning is that because you have so many different rules, I mean, we can sit on this call as people who have spent a lot of time as professionals working in this area, and often we can figure out the answer. We can't always figure out the answer, but when you're thinking about the student perspective, it's much harder for them to really have an understanding of what, where it's going to matter and what their different rights are, because they are going to be different in each particular situation.
Let me just underscore one thing you talked about there, Kirk, which is that no matter where the records are, on campus or off campus, no matter whether we're talking FERPA or HIPAA or dealing with the state statutes, if they are relevant to whatever the legal issue is, they will eventually, almost certainly, be disclosed. And the question is really a procedural one rather than a substantive one. The right to confidentiality is not absolute if the health status of the student is relevant to the underlying claim. Would you agree with that, Kirk?
Yeah, I mean, I don't think it's, I think it's certainly a likelihood. I mean, there's various ways to resist that. But yeah, as I said, if the records become relevant, the process is designed, at least the HIPAA process is designed to make sure that the records are used only for purposes of the litigation. You can't use it and then go out and do something else with it, but there is a process to have those records flow in the context of litigation. I mean, it's usually subject to a protective order and things like that, but it does come out in that context.
And that would be true, I think, under any set of rules, but the key is that whoever the defendant is, and this is true whether it's the university or someone else, is going to have a right to defend itself against a claim raising that sort of an issue. So under some set of rules, under some set of process, and probably a protective order, those records will be disclosed at some point.
I think the interesting question, though, and I wonder if we could just touch on it just for a moment, is I think if in most situations of what we're describing, the student would have the same level of protection with their records of the care that they received at the on-campus student health center, if on campus versus off campus. The only exception would be, can, for example, the investigators, OCR, access their records? Because that would be the one situation where they would have less protection having had care at the on-campus center versus an off-campus site.
Well,
that is a nuance.
Yeah, I mean, and it's an important nuance, and I guess I'm not actually sure I agree with that description. I mean, in a litigation context,
nor do I.
in a litigation context, I'm not sure we can say the rights are the same because there's different processes, and that doesn't mean the end result is necessarily going to be different, but there's a different series of steps, and that doesn't mean, so you may not end up with the same answer. The OCR question is OCR, and I assume by OCR we're meaning the Office for Civil Rights.
Yes.
Which is the HIPAA enforcement agency. Very interesting question as to, for example, if it's an on-campus facility that's clearly subject to FERPA and not subject to HIPAA, I'm not sure why OCR would have any ability to access that information in any context. They also don't tend to go in and really look at, dive into patient records for the most part, unless the patient has filed a complaint. So, but again, each of these scenarios you have to really walk through. Steve was laying it out in terms of who's asking, but it's who's asking, who's got it, why they've got it, what they're going to do with it, what the interest is. And because, and that's hard enough when we're just talking about a doctor without the FERPA overlay. It becomes incredibly complicated when you add FERPA onto it and then try to deal with it from all the different perspectives that a university who's providing, is a college, is a hospital, is an academic medical center, is all of those things. It's just a very difficult overlay.
Okay, Kirk, thanks. I think that sets us up nicely to move on to the next one, because I think we could probably spend a lot of time on every variation or detail of each of these and have a lot of good information, but let's see if we can focus on a couple of different broad questions to put some general things in context. So our next scenario is a student who has filed a civil suit against the university following a reported sexual assault. The suit involves several allegations, including concerns about the handling of the assault in the campus judicial process, as well as concerns about the quality of care provided by the on-campus counseling center. So this scenario blends a couple of different types of suits, and we want to point out or have our panelists discuss why medical malpractice as one of the issues might be something of a special category as opposed to the other types of claims that a student might make against the university in which health treatment records would be at issue also. So if Steve, you could lead off addressing the questions for this scenario.
Sure. And again, as we talked about in the last one, these things are incredibly fact-specific. So a lot of specific facts of the case are going to make a lot of difference. In this case, because the quality of care is specifically put at issue, which it wasn't necessarily in the last scenario, one of the things that can happen is that the counseling center itself is almost certainly going to have the right to speak with its own legal counsel, which is going to be the university counsel, about defending that claim. Again, the two privileges sort of dock together, so that doesn't mean that the information can be shared more broadly at that stage, but that consultation can take place. Now, given the structure of this lawsuit, it also appears quite clear that the medical information has been put at issue, and so there's probably going to be a waiver of privilege under state law, and it is going to be able to be disclosed. This is the one issue where FERPA and state law and HIPAA and state law may be a little bit different in terms of the procedure, although again, I think the end result will be that whatever records are relevant, and that's a very flexible term, will ultimately be disclosed and come out in this litigation, although again, as Kirk pointed out, quite likely under some form of protective order so it doesn't get filed in the publicly accessible court docket. These things are probably going to be okay under both FERPA and under HIPAA. And before I turn it over to Sarah and Kirk for elaboration, we do want to bring in one more point here. I'm going to move one slide forward, which is litigation holds. Because now that we are in litigation, indefinite litigation, we have another set of rules that we have to worry about. And that is that anyone who is a party to a lawsuit, and also anyone who is a party to potential lawsuit, has a duty to secure and to preserve all records that are potentially relevant to that litigation. Not to do so is what is referred to by the courts as spoliation of evidence, which is a bad thing and can lead to all sorts of sanctions in the litigation. This duty arises not only when, as I said, when a lawsuit has been filed, but also when a lawsuit is, quote, reasonably anticipated. So if you have some reason to believe that you are going to be sued, that might come about as the result of an OCR charge, where it seems clearly headed toward litigation. It might be a letter from the other person's counsel starting to ask questions and hint that there's going to be a lawsuit. It could be lots of different reasons. What is relevant, as I said, is defined quite broadly, and you generally, when you are dealing with this, want to cast a wide net to be sure you don't miss anything, because the sanctions really can be quite severe. When you're dealing with electronic records, and in the medical context nowadays we quite often are, if more often than not are, we need to preserve not only the record but also the metadata for the record, and that would show things like who accessed, when it was accessed, and so forth. The records that are being held generally are held apart from the main record in some form of segregated repository. And one of the big questions in this context is, what are the best practices for medical records? Typically in litigation, what will happen is that all the records will be sent to counsel's office, where they will be secured in some way so that they are still protected from general disclosure. But that's not always the case in medical records, and I believe, and I think Kirk probably has more expertise at this than I do, that a lot of the software now in which electronic medical records are kept has the ability to secure and segregate those records. So that might be the best way to deal with those sorts of things. That's more of a best practice thing than a strictly legal thing. So with that, I'm going to go back here to the scenario, and I will, Brenda, I don't know if you want Kirk or Sarah next. Somebody jump in.
Sarah, why don't you go ahead and take that if you have some thoughts on that?
Yeah, so I think, and just kind of talking a little bit about what Steve was talking about, the litigation hold, I think this is an interesting case where you have on-campus counsel who maybe have two roles here, both as defending the on-campus healthcare providers as well as potentially defending the university. One of the ways that we've, and that can potentially be a conflict, and also their need to access the student's records to defend the healthcare provider might be different than their role in terms of defending the university. So one of the ways that we've talked about litigation holds or thought about them in terms of best practices in mental health is to simply sort of, the litigation hold is acknowledged, it's received, but without confirming or denying that there are records or that the students received care until we actually need to move forward with release of those records, that those records are actually maintained at the health center rather than sent to counsel where potentially they could be accessed by the university for purposes of defending themselves in the civil suit versus defending themselves related to the medical malpractice claim, if that's going to move forward. So those are some of the things that we've talked about doing in terms of protecting that sort of dual role that university counsel may have related to accessing the records before the process has moved along, that access is appropriate for university counsel in both of their roles.
Thank you, Sarah. In the interest of time, we're going to go ahead and move to the third scenario and cover that. Let me just get back through the litigation holds information. So in this case, a student is referred from an on-campus counseling center to a local emergency department for thoughts of self-harm. The student later files a civil action for mental distress against the university, claiming that the distress was triggered by sexual harassment from a professor. So we have a number of questions related to that scenario. And Sarah, if you would like to kick this one off.
Yeah, so part of the question we've talked about is kind of the release of records from the counseling center to the emergency department, and then the accessing the emergency records by the on-campus counseling service. So that's one piece of it. So presumably the care that she had provided on campus would be covered by FERPA, whereas her off-campus records would be covered by HIPAA. There are various laws related to protection of mental health records. Again, that varies quite a bit by state, but most state medical privacy laws allow some access for purpose of treatment, so that healthcare providers can get access, even without explicit consent, to certain components of the record so that they can actually coordinate care provided the information that's needed for treatment. That may actually allow the on-campus counseling center to access portions of her record without consent, and certainly with consent, that would be a typical practice, would be for the counseling staff to access those records. Now, one of the interesting nuances of FERPA, and this is actually one of the challenges with it, is that FERPA doesn't actually allow release of records for purposes of treatment. So it's one of the cases where the bar of FERPA is actually higher than the bar of HIPAA. So in many cases, campus centers have to have explicit consent from students to release information that might be permissible by state law and also permissible by HIPAA. So whether the counseling center could access her records or what portion of them would depend on the state law. In most cases, they would have some information about that. interestingly, they would not then be able to re-release those records to the university. And some of the things we talked about before about release related to the lawsuit would then come into play. So the role of the counseling center to have access to those records for treatment of that patient or that client might be very different than their role, than those records that they would hold at the health center and when they became relevant to the lawsuit.
Okay.
Kirk or Steve, any comments on that?
Sure. So I agree with what you said, and I think the distinction here comes down to largely the fact that the claim is not a malpractice claim against the on-campus counselors, which means that the general privilege for the on-campus counselors is going to trump FERPA rather than vice versa. If those records are accessed, whether it's from the off-campus department or from the on-campus counseling center, or excuse me, if they're relevant to the underlying claim, even though it's not a malpractice claim, they probably will still come out subject to some form of protective order, but the procedure will be very different. It probably will require a subpoena, but the institution will have a right to defend itself, and if those records truly are relevant to the claim, they will come out ultimately under some form, I think.
Anybody else have thoughts on that scenario they want to add before?
No, I think that what Steve said is right. I think the other sort of odd play that has a little bit of difference between state law and HIPAA, for example, is that a lot of state laws have provisions that basically say if an individual, it doesn't have to be a student, but an individual puts their medical condition sort of at issue in a case, that makes it easier to get records. A lot of people sort of are familiar with that, and they try to follow that in the state version, but HIPAA doesn't have that kind of idea. So you still have to follow the HIPAA litigation process and go through subpoenas and protective orders, even if it's a situation where the individual has put their medical information at issue in the case. That's the situation where HIPAA essentially preempts the weaker protection of state law because the floor of HIPAA is higher than that.
Okay, thank you very much. I'd like to thank our panelists for their comments on all three of those scenarios. And now we will move on to a Q&A section. I'd like to remind everyone at this time that you can submit a question for discussion by typing it into the text field to the right of the PowerPoint window, and we will see it. It is unlikely that we will be able to answer all of the questions directly during this period, but we will certainly try to get either the gist or as many of them as we can included. I'm going to start with one of our prepared questions while we wait for a few more questions to come in. So one of the concerns that has come up today is what is the incentive effect on students to use the University Health Center if they either don't understand or feel that there are different set of standards or rules, and how does that impact their decision to do that, and which students would be most impacted or most affected by that sort of either misunderstanding or actual results that they might experience. So Steve, could you maybe kick us off on that one?
Well, I would hope that it wouldn't, and I don't think it should, because really the distinction between on-campus and off-campus is relevant in a very narrow set of circumstances. It really is an issue pretty much only if there's a lawsuit and only if the lawsuit is unrelated to the provision of care. Apart from that, the rules pretty much line up with each other, and even in that rare situation, the records are not absolutely protected. The procedures are different, but if the information truly is relevant to the lawsuit, even though the lawsuit is unrelated to the provision of care, they almost certainly are still going to come out. So for me, it's a largely theoretical distinction and a largely theoretical difference that is just going to be so rare and makes so little practical difference that I don't think that it should be a disincentive. I certainly hope it's not.
Well, this is Kirk. Let me take a slightly different perspective on that. I think that if we're focused on things like litigation, I agree with what Steve is saying. I think that in general, the HIPAA rules actually allow information to be disclosed in a much broader range of situations than I think the FERPA rules do. Now, it may be that a lot of those situations are things that an individual wouldn't, I don't want to say wouldn't care, but where it wouldn't have any direct impact on them. But the, one of the criticisms of the HIPAA rule is that it is very permissive in terms of what people can do with information. So an off-campus facility actually can use information for a much broader range of purposes than I would think you could in the university setting. And in that sense, FERPA may provide some better protections, but you can also imagine slight examples where it's possible that HIPAA would be better in a particular circumstance. And so that's just the kind of thing that, unless you're an incredibly savvy person who knows in advance what's going to happen to this information, it's almost impossible to figure that out.
That's a good point. Oh, sorry. Go ahead.
Yeah, and I think I would echo both what Steve and Kirk said. I think if you're a student or a student's family and you're asking yourself the question, if I get care on campus, is my confidentiality and privacy going to be protected? I think under FERPA or HIPAA or state medical law, I think the answer to that is absolutely yes. And as someone who works with this on a daily basis, who works with hundreds of practitioners across the country, I think we all feel very confident in what we do. There are definitely nuances. I would agree with Kirk that sometimes we actually struggle with FERPA because of the restrictions it has in using information in ways that we sometimes need to use information that are permissible under HIPAA. But I think there's definitely reasons to simplify this and make it less confusing. But I think students' medical information and mental health information is safe on campus.
And I would just add to that, much of this can be dealt with up front when the student first walks in with the informed consent process, and you can spell out what the rules are.
Yep.
Hopefully everyone's doing that.
Well, but in the reality, I guess, I was in a medical facility the other day for something, and I sat and looked at a thing on the wall that was a 4-foot-high notice of medical privacy. I mean, it was. I don't think. I think the idea when these rules were written was that the doctor was going to sit down and have a half-an-hour conversation with the patient about what their privacy rights are. And I think, unfortunately, the reality is that almost never happens. I mean, they're handed a piece of paper. They may not even be. They're handed one piece of paper. The piece of paper usually says you've received a different piece of paper, which is your privacy rights. You may or may not even have gotten that. It doesn't mean you've understood it. So I think it's the idea of notice in these settings is, I mean, it's a protection in almost all privacy rules, but I think we're generally coming around to the conclusion that it's very seldom really effective in terms of letting people know what's really going to happen.
Yeah, fair point.
Okay, thank you, panelists. So we have a couple more questions lined up, but we have a number of great questions coming in from our viewers. I would like to tell you that based on the volume of questions, it's clear we're not going to be able to answer all of them directly, and so we will do our best to reply offline, if possible, after the webinar. So the one topic that has come up in several questions, so I'm going to sort of address it generally, is the issue of disclosing health information for state public health reporting, communicable diseases and things like that have a separate statute affecting when they have to be reported by the medical provider. Is that an additional complication? Is that not particularly distinctive in this context? But we've had several questions on that. Kirk, maybe can you kick off on that? Do you have an idea of that?
Actually, Steve, do you have any thoughts on that? I'm not sure that's one I have.
Let me jump in, because that is more of a FERPA question, and it's an interesting one, which actually FERPA trumps those state laws. There is no exception under FERPA that allows you in general to comply with those kinds of requirements when they are simply routine reporting. However, under FERPA's health and safety emergency exception, which is one of the many exceptions under FERPA for disclosure, you can disclose to a state agency if the student's condition poses a broader health and safety concern. So, for example, if we're dealing with measles, you may well be able to report that because that's a threat to others and the state agency can help with that. But if they're simply saying, we want to make sure that we have everyone's immunization record, or you need to report, every case of bronchitis or something, then you actually could not do that. FERPA would, because the two laws would conflict, FERPA would prevail as the federal law, and you would not be able to report to the state agency.
Yeah, and HIPAA is exactly the opposite on that. I mean, HIPAA has very particular provisions that essentially carve out those public health reporting laws, and there's a provision that talks about disclosures that are required by law. There's also a specific exception that basically says for public health reporting, those are clearly permitted disclosures. So that would be a situation with a very different result.
Yeah, this is a situation that those of us who are providing, who are covered by FERPA and are also have reporting requirements by state struggle with, and this is a case where FERPA is more restrictive in a way that's actually somewhat problematic. Many campus centers handle it by getting upfront disclosures and notifying, just simply letting students know and asking for consent up front that we do follow state reportable disease laws. But this is a very common challenging scenario in student health.
Okay, thank you. I'm going to jump ahead to actually one of our prepared questions because I think that it addresses something that has come up in several of the questions coming in from the audience as well, which is what do we do? Is there a way to address this specifically? We've said up front FERPA and HIPAA may sort of both be not relevant in certain cases, but state confidentiality laws would apply. Is that the safety that we want? Should there be a federal answer? So I'm going to jump to this question. Should university health centers be subject to targeted restrictions, meaning something that is particular to the situation of a health center at a university? Because by its very nature, it's a unique situation where sort of the host of the student is the university providing their housing and everything else, but also either contracts for or provides the health center and the treatment services. It's just a little of an unusual situation compared to what they would have at most other points in their lives. And so should that be the subject of a particular targeted either legislation or regulation, or how should that be addressed? Steve, I'm going to start with you just because you had that comment at the beginning about the state law sort of covering that place where FERPA and HIPAA may not apply.
My general inclination for this question is no. And that's because we have a complicated enough situation already, and I don't think we solve that by creating more complications. I think if we dealt with state law and made sure that it was sufficient, regardless of whether you're on campus or off campus, that would be a better fix, because FERPA was never intended to be a medical privacy statute itself. And introducing that into FERPA creates even more complications. And I say this having spent the last 3 months or so actually talking to the senator's staff and others about how that might happen, and everything we thought about just ended up being more and more complicated. It's a very difficult thing to target.
Yeah, and just to add to that, I mean, I think that you end up having this sort of weird exception that says, health information is regulated by HIPAA at the federal level for all health information that's covered by the rules, unless it happens to be a student getting it in this particular context. And I mean, you can understand the logic of that, but it's kind of a weird result to some extent. And I think that when you, I mean, I haven't gone back in the FERPA legislative history, but I mean, it's not, treatment records or these health center kinds of issues were not certainly the core of what was being covered by FERPA. They're obviously covered by FERPA, but it wasn't sort of the original idea of some of that. And I think it's very complicated. When hospitals and others are trying to figure out what to do to have all these different rules, I think the state law at this point is basically a sort of default if nothing else is applicable. But the state laws are wildly inconsistent, and I don't look at state laws as, I mean, basically HIPAA exists because the state laws generally were not consistent enough or covered enough information or had any kind of general applicability. And so I also don't think we want a third or a fourth law, depending on how you count that. But I could see trying to modify the rules to make everything under HIPAA here. But that's the choice we're gonna have to make. Are we going to treat students differently in this one context than we are every other kind of patient?
And I would sort of, you know, if I were designing the world, you know, would say that ideally, I think from those of us who are working in this, simply having student health records covered under HIPAA with all of its, while there are complications with that, would probably be a better scenario. I don't think there's anything about HIPAA that would be problematic for student health. Many of us are already have sort of a portion of our patients covered under HIPAA and a portion under FERPA, so we're already dealing with the law. And I think, you know, more than just protecting privacy, as we've discussed, there are actually permissible disclosures under HIPAA that we really need as student health professionals to be more effective and actually struggle sometimes with some of the restrictions of FERPA. So I think reconciling and making health information is probably the best way to go.
Well, yeah, there's one of the questions actually asked, could we explain the logic of the HIPAA exception for educational records? And I was tempted to say no. I can't. I'm not sure I can. I mean, I'm sure there's a history to that, but I mean, it doesn't make a lot of sense to me to say that, you know, and again, when you go, if you walk into a hospital, I was just with my daughter in the Georgetown University Medical Center recently, and the idea that, you know, a student there has different rights and protections. We can debate whether they're better or worse in particular contexts, but they're just different than every other patient that walks through that door is an odd result.
Well, let me respond to a couple points there. Sarah, at your institution, which is a large institution which has HIPAA coverage already, it probably wouldn't be that hard. And many schools that are in your situation actually voluntarily comply with HIPAA standards just because it's easier to do so, and that's certainly fine. But there are probably thousands of smaller schools that are not currently subject to HIPAA, and for them it would be quite difficult to gin up to have that whole thing flung at them. And even if it were, they wouldn't necessarily even still be subject to HIPAA because many of them do not bill at all for services, let alone electronically.
Well, the way you would deal with that, though, is to take out the exception in HIPAA and still have the rules in FERPA, because then you'd be covered by FERPA in that situation. If it was just a student health center that just treated people who walked in and gave them a pill and moved on and didn't bill anybody, you're absolutely right that they wouldn't be covered by HIPAA, but the HIPAA exception wouldn't be relevant there. If you just got rid of the weird part, I think, is where information is otherwise covered by HIPAA except for that exception, which would be the Georgetown Hospital kind of situation. I think that's the part where it's really kind of an odd result.
The Georgetown Hospital actually is covered by HIPAA, not FERPA. So this is something maybe we should just clarify. The Student Health Center is covered by FERPA. But if you have a generally accessible hospital like Georgetown does, or like we did at Ohio State when I was there, and people who happen to be your students go there on the same terms as patients off the street, they actually are subject to HIPAA under that circumstance and not FERPA.
And that's a really interesting, I think this whole question of do people even know where the line between HIPAA and FERPA ends, I think is very interesting, actually. We struggle with this on many campuses. You know, if a student has graduated and they're being seen over the summer, do they move to being covered by FERPA to being covered by HIPAA? If you're operated by your academic medical center, what's the balance of how much of a campus health center you have to be FERPA versus HIPAA? So there's actually a lot of confusion even within student health about what portion of our operations are HIPAA covered, what portion are FERPA covered.
What if you start out at a student center and then get referred to the hospital?
You're covered by HIPAA.
But the first part, what happens to the first part?
It's FERPA.
FERPA and then HIPAA, yes.
And how does the student understand that?
Okay, well, clearly a lot of room for debate and opinions on that question. So want to hit one more topic that has come up in several questions from the audience. I hope it's not a little bit off topic, but I know it's something that at least everyone who is at a campus between 18 and 22 probably has a very strong interest in, and that is the question of disclosure specifically to parents in any of these situations. It can come up in a couple of contexts on different questions. One, if back to the public health issue on those sorts of reportable conditions, and then also if a student has some kind of special needs profile that there's either behavior or something observed at the university that causes concerns. At what point is the university able to share any of those records, if ever, with the parents of that student?
So let me jump in
on that, please.
That one. So this is actually one of the main distinctions between K through 12 and college. FERPA rights belong initially to the parents of the student, and the parents have the right to access records until one of two things happens. Either the student turns 18, and in high school this starts to happen, although people tend not to notice it, or when the student goes to college. And age does not matter at college. When Doogie Howser went to Harvard Medical School, he owned the FERPA rights, and mom and dad no longer had a legal right to demand access to his records. Now, FERPA allows us to share student information, including student medical information, treatment records, if state law would allow us to do so as well, under several different sets of circumstances. First of all, if it's a health and safety emergency, under the exception I mentioned before, mom and dad quite often will be someone that you can disclose to because they can help deal with that. Second, if the student is a tax dependent of the parents, you may continue, not required, but you may continue to share any information from education records with the parents if you have confirmed that the student is a tax dependent. But the main one, and I would suspect this is something that probably happens in a lot of health centers, is with the consent of the student. When the student comes in up front, I believe sometimes they are asked whether they consent to various kinds of disclosures, including, in some cases, to mom and dad. Sarah, do you know, is that a common practice?
Many campuses do not actually allow for blanket consents, and that is something that is certainly requested, but one of the challenges is when you're working with young adults who are developmentally changing, you know, what a student might consent to in August is different than what they might consent to in December. So sort of forward-looking blanket consents are usually not a standard practice in student health. That being said, we frequently, commonly get student consent and discuss care with parents.
And would you do that on a case-by-case basis?
On a case-by-case basis or condition-specific, typically condition-specific and, event-specific.
So I really think we should talk to your mom and dad. Is that okay?
Yep.
Yeah.
Or we're caring for you for this specific condition over a period of time, and we would like to disclose, we would like to have ongoing conversations with your family. Very common practice, done lots and lots of times.
Makes sense.
Okay, thank you, everyone. I don't think that we're going to get to our last couple of prepared questions, and probably you're going to have to start wrapping up here fairly shortly. Dave, would you like to take it back for IAPP and start winding us up?
Certainly, yes. Thanks very much, Brenda. And thank you, Steve and Kirk and Sarah, for that very helpful presentation. I'm sure many of you out there are both gained some insight and also leaves a lot of questions to be answered still. So an evolving situation as always. And as you can see in front of you now, the presenters, including Brenda as the moderator, have made their contact information available. So please feel free to reach out to them following the program if you have questions. I'm sure they'd be happy to help as they can. Also, we did receive a number of questions that we were not able to get to. So we're going to do our best to try to get to some of those offline to the extent that we're able to do that. So thank you very much to all of the panelists for today's program. I hope it was informative for those of you in the audience. Before you drop off the line, if I could encourage you to just take literally 2 minutes to communicate with us here at the IAPP about how you enjoyed this program, if it met your expectations. It's a very simple form to fill out, and we really do value and appreciate your feedback. There's also an opportunity in the form to let us know what topics and subjects you'd like to hear about moving forward, and we mine that regularly to see what we want to offer for topics. So please, please do let us know what you want to hear about in the future, and do let us know how you enjoyed the program today. That's a live link in front of you on the slide now. And thank you to all of you that took the time to join us today, and thank you, of course, especially to the time and effort that all us panelists put in to the program. Brenda, for some excellent facilitation and moderation on the program. We really appreciate it. And of course to the Congressman and the Senator for providing us with some opening remarks and teeing off the conversation today. We really appreciate it, and we're very happy to have been able to host this program today. If you are an IAPP certified privacy professional and you were the named registrant, this program is available for 1.5 CPE credits, and those credits will be granted to you automatically to upkeep your IAPP certification. If you're listening in and you'd like to receive those credits and you're not the registered name, please hop on over to our website under the certification tab, and you can fill out a very simple to fill out form to receive those credits to upkeep your certification. If you're an attorney and wondering about CLE credits or continuing legal education credits, they may be eligible for you, but that varies by jurisdiction, and we do not pre-certify these programs. So you'll need to apply within your particular jurisdiction. And if they require supporting materials, speaker biographies, program outlines, etc., please contact me, and I would be more than happy to try to provide those materials for you. And as you can see on the screen in front of you now is my contact information. Again, I'm happy to provide supporting materials to answer any of your questions regarding this program or others. And if you'd like a copy of the slide deck, please email me. That's my email address in front of you there, and I'd be more than happy to provide a copy of the slides for you if you'd like those for reference as well. So with that, one last time, thank you very much, and I will bring us to a program close. We hope to see you on a future IAPP webinar. Thank you, everybody.